Hi everyone, I welcome you back to our channel, Ego Mindset at the bar. So today we are going in for contract law 1, and in our campaign of simplifying contract law 1, we are discussing one of our last topics. And in this one, we are going to look at the I-Twist case and the doctrine of promissory estoppel. So I urge you to subscribe. Touch that subscription button below the video. Share with your colleagues if you watch, like, keep on the comments coming. What video do you like next? So, what is I-Twist case? What principle was laid down in I-Twist case? And if you hear the doctrine of promissory estoppel, what does it mean? Where does it derive its origin? Who founded it? So, the doctrine of promissory estoppel was born in I-Twist case. That's why I've made a video and put them hand in hand. By the end of this session, you should know the principle in I-Twist case. You should also know what the doctrine of promissory estoppel means. You should also know the exceptions to the general rule in I-Twist case and the doctrine of promissory estoppel. I dedicate this video to the Nkumba University students who are going to have your contract law paper tomorrow. This video is for you. Appreciate I-Twist case and the doctrine of promissory estoppel. So, promissory estoppel is a principle of equity. Highlight my words. Is a principle of equity to effect that if someone makes a promise which another person acts on, is stopped from going back on that promise, even though the other person provided no consideration. This is interesting. Take an example here. Me and my friend, Counsel Joshua, I tell him that I'm going to pay for you a visa and a passport for you to go abroad. That is my promise to my friend, Counsel Joshua. Then Counsel takes reasonable steps. Because he's going abroad, he sells his house, his plot of land, and all his property. Because now he's going to start living abroad. Then, after I decline my promise, in law, in the doctrine of promissory estoppel, I will be stopped from going back to my promise to make it real, as it was held by Lord Denning in I-Twist case. I urge you to look at section 1 of the Contracts Act, Cap 284, which shall define for us a promise, a promisor, and the promisee. And in this essence, in promissory estoppel, a promise shall be that offer the person gives to another. The promisor, that person who makes that offer or that promise. The promisee is the person who has been given that promise, who has been given that offer. But in promissory estoppel, the promisee does not give consideration. His consideration is the reliance. The promisee should show that I relied upon his words. That is the doctrine of promissory estoppel. The modern doctrine of promissory estoppel is largely based on the judgment of Lord Denning in I-Twist case. That is Central London Property Limited versus I-Twist House Limited. So, in this case, Central London Property Trust Limited versus I-Twist House Limited, a case of 1947, Volume 1, King's Bench, page 130. The facts are that in 1937, I-Twist leased a block of flats from Central London Trust Property. So they were given a ground rent of 2,500 pounds a year. Then they paid that money until the time of World War II came in. During the time of World War II, they became unable to pay. Why? All the flats were vacant due to the effects of World War. High trees could not pay the rent. In 1940, the landlord agreed in writing to reduce on the rent up to 1,250 pounds a year, but for only the duration of the war period. But after the war in 1945, occupancy returned to normal. People came back to the flats. Now, in 1946, the landlord, Central London Property Trust Limited, sued High Trees in 1946 to demand full payment of the rent in the second half of 1945 after World War, and he also hinted on recovering some areas. Get me well. He requested for the money of 1945, but he talked on getting the rent of the early months. So the issue before court was, could the landlord claim full rent during the period of the war where he had given the promise to the tenant, and was he bound by his promise to accept reduced rent? That is the issue we are going to look at. Let us now look at the judgment of Lord Denning, which laid down the doctrine of promissory estoppel. In his judgment, Lord Denning stated that the plaintiff's claim for full rent of 1940 to 1945 during the period of war would fail even if the defendant provided no consideration. That is the doctrine of promissory estoppel. Why? Because the defendant promised, the plaintiff promised the defendant that he would reduce the rent, and the defendant worked upon his promise. Lord Denning continued and said that the plaintiff could only recover the full rent that was collected by the defendant High Trees after the period of the war, after the condition of the war, after 1945. Lord Denning was clear that before the period of 1945 to go 1945 backwards to 1940, the plaintiff could not recover that money, the full payment, because he had promised. His promise amounted to promissory estoppel because the defendant relied upon it. That was the rule, that was the principle in the case of Central London Property versus High Trees, and that is the High Trees case. For those of you who have just heard of it, it is a keen topic, it is a key case, it is sacrosanct and paramount for your understanding of the law. Study the law to understand it, not to pass exams, because these are the principles you're going to apply tomorrow. Now, for a person to rely on the doctrine of promissory estoppel, they should prove to court the following prerequisites. Number one, there has to be a contractual relationship between the promisor and the promisee before the promise is made, as it was for High Trees case. There must be a clear and unambiguous promise for the promisor, from the promisor to the promisee. The promise should be clear and unambiguous. Number three, there must have the promisee must have acted upon the promiser's promise. There should be reliance. You should show that you relied upon the promise. As I gave you the example of me and Counsel Joshua, where I assured him that I will provide for you with a visa, a passport for you to go and start living abroad. If I do not pay, it means that I'm stopped from going back to fulfill my promise. That is the doctrine of promissory estoppel. Now, number four is that it must be inequitable for the promiser to go back on his promise and revert to his strict legal right. This means that if returning back to the strict right is not fair, the court will not allow promissory estoppel. There should be reasonable fairness that indeed the other person worked upon his promise and he should go back. He should make his promise clear and good. As any general rule, the doctrine of promissory estoppel has a number of exceptions. I'm going to polish these ones, but you're going to understand them. What are the exceptions to the general rule in high trees case? The exceptions to promissory estoppel as an equitable doctrine. Number one, this was stated in the case of Combe versus Combe. Court said that the doctrine of promissory estoppel can only be raised as a defense that is not a shield, as a shield but not a sword. It can be only raised as a shield and not a sword. You cannot use the doctrine of promissory estoppel to attack, to rely on it as your basis of the case. In Combe versus Combe, a case of 1951, volume 2, King's Bench, page 215, court held that the doctrine cannot be raised as a cause of action. This means that the doctrine of promissory estoppel can only be raised as a defense to a claim and cannot be used as a basis for a case. Now, what are the other exceptions? We are going to see the requirements of promissory estoppel and make their opposite. Where we said that the promiser must show reliance. If the promiser does not show reliance, if there is no reliance, that means promissory estoppel will not work. For promissory estoppel to work, there must be reliance. As an exception, if there is no reliance, the doctrine will not work. That is it for promissory estoppel. The general rule in high trees case, judgment of Lord Denning, where I stated that if a person, a promiser, promises another person, and the other person, the promisee, relies and works upon the promise, the promiser cannot escape liability, is stopped from fulfilling their promise. Thank you very much for watching Legal Mindset at the Bar. Subscribe, hit that subscription button below the video, turn on the notifications, because in this period of exams, we are bringing a number of topics to your attention. We want all our colleagues to successfully pass. Share with your colleague. Don't let them fail. Don't let the semester slip up. So, this video, I said, I dedicated it to Nkumba University students in 1-1 as you're doing your exams next week. Thank you very much.